हो गया है, आप इसको किसका AP number 290 of 2023. Admit. Issue notice to the respondents for which recusals be filed. Within 15 days from today. Who's be post? Office to tracks be posted. With the records we call for from the concerned court. Post this case on January couple level. 6th of January.
For hearing order of 51, rule 11, item 16, second equal 75 of 2017.
Plaintiff appellant is the in the second appeal against the judgment of affirmance. Now, the suit was brought by the appellant as a plaintiff for declaration that the suit land is the joint property of plaintiff and defendant number 15 since the date of purchase, that is exhibit 7, and the suit land, if there is any defect that has been cured by virtue of adverse policy. Now, if you also may kindly come to the appellate court judgment, the paragraph 11, that is at page 18, in our page 6. From the lower court case record, it appears from the pleadings of the parties, materials, evidences brought by the parties such and such issues. Whether the suit is maintainable, whether the suit is undervalued, whether the proper description of the disputed land is given, whether the suit is barred by limitation or act and any other act, or principles of res judicata. This is the only issue which has been decided. That is issue number 3. Then whether the plaintiffs and defendant number 18 jointly constitute the undivided Hindu family, whether the said family has title and possession over the disputed land since 1970. These are the two issues. The issue number
which have been decided.
Yes, issue number 3 and issue number 5. Now, subject to Lordship's time pressure, I will not take much more time. Lordship may kindly come to the trial court judgment first. Only issue number 4, that is with regard to the res judicata. The Lordship will find para 16 of the trial court judgment is the consideration. That is page 32, running page 32.
Turning page
32 or inner page 7. Hindi है.
yes.
निस्तारण बाद बिंदु संख्या 4. Now, your Lordship, just case has been discussed. What is the case? Your Lordship, just see. I am skipping.
What is the finding?
Finding. That is what I was skipping all these things. Your Lordship, may kindly see page number 18. Discussion with regard to section 11. Then para 19 is the important.
Yes.
बाद पत्र के अवलोकन से यह स्पष्ट है कि वादीगण ने अपने स्वार्थ एवं कब्जे के अनुतोष का एक और आधार भी माना लिया। सॉरी, उसके पहले वाला पैरा 18 होगा, पैरा 18, सॉरी, पैरा 18 व्यवहार प्रक्रिया संहिता पेज नंबर 9 का उधर नीचे लास्ट धारा 11 के अनुसार पूर्ववर्ती बाद और पश्चात जहां बाद में प्रत्यस्त और स्वतः विधान
विद्यमान विवादित विषय
होना आवश्यक है तथा दोनों बात उन्हीं पक्षकारों के मध्यवर्ती के अगर नए से दर्ज है। कोई
इस वाद में यह स्वीकृत है कि
कोई दावा करते हैं कि करना चाहिए। इस बात में यह स्वीकृत है कि वादी गण प्रतिवादी संख्या 18 के पुत्र। यह भी स्वीकृत है कि पूर्ववर्ती बात पूरी तरह से सुनकर विनिश्चित कर दिया गया। पक्षकार वहाँ है पद के अंतर्गत पक्षकारों के उत्तराधिकारी में आते हैं। मतलब न्यायवादों में केवल उन्हीं पक्षकारों का पर ही नहीं अपितु उनके संसर्गों पर भी लागू होता है। इस प्रकार यह स्पष्ट है कि पंजीकृत केवला संख्या 12/5/1978 एग्जिबिट 7 के आधार पर विवादित संपत्ति पर प्रतिवादी संख्या 18 के संबंध में स्वत का विनिश्चयन संबंधी निष्कर्ष वादीगण पर भी बाध्यकारी है। उपरोक्त पंजीकृत केवला पद 7 के आधार पर विवादित संपत्ति पर वैध शर्त का अनुतोष वादीगण के लिए इस बात में प्रति न्याय के नियम में से काल बाधित है। न्याय के नियमों से बाधित है। Then another point, पैरा 19 वाद पक्ष के अवलोकन से स्पष्ट है कि वादीगण के अपने स्वत एवं कब्जे के अनुतोष का एक और आधार भी दिया है कि वादी का परिवार पंजीकृत केवला पद संख्या 7 के निष्पादन के बाद से विवादित संपत्ति पर प्रतिवादीगण एवं अन्य लोगों को जानकारी में निरंतर दखलकार चला आ रहा है और लगभग 25 वर्षों के निरंतर दखल के में रहने के कारण वादी संयुक्त परिवार के विवादित संपत्ति पर वैध शर्त अर्जित कर लिया। स्वतःवाद 130/80 के निर्णय अवलोकन से स्पष्ट है कि वादीगण द्वारा इस बात में अपने दावे के संबंध में उठाया गया प्रतिकूल कब्जा का आधार न तो उस बाद में उठाया गया और न ही उस समय प्रतिवादी संख्या 18 को प्राप्ति था, क्योंकि उपरोक्त बात का वादपत्र 1978 में ही न्यायालय में दाखिल किया गया था। ऐसी स्थिति में वादीगण के दावे को अंश की किसी अंश के सीमा तक वादी का यह वाद न तो प्रारंभिक न्याय में बाधित है और न कोई पूर्व में कोई निर्णय हो चुका है। इसलिए यह पता हो कि प्रतिकूल कब्जे के आधार पर वैध शर्त के अनुतोष की जांचना से संबंधित विषय प्रति न्याय से बाधित नहीं है। इट इज नॉट बार्ड बाय रेस जुडिकाटा। तदनुसार यह वाद बिंदु आंशिक रूप से वाद के पत्र में इस प्रकार निर्णय दिया जाता है कि पंजीकृत केवला पद 7 के आधार पर स्वत की उद्घोषणा संबंधी अनुतोष का विषय प्रिंसिपल ऑफ नेचर न्याय से बाधित है, किंतु प्रतिकूल कब्जे के कथन के आधार पर स्वत एवं कब्जे की उद्घोषणा संबंधित अनुतोष न्याय से बाधित नहीं।
Declaration of title is barred by res judicata.
That is the first paragraph.
That is the first paragraph.
The second paragraph.
Adverse possession, claim of adverse possession is not barred.
Not barred. So there are two findings. First part, it is barred by res judicata, and second part, it is not barred by res judicata because the second alternative relief.
That's
That
right.
is the reason relief was sought for in two forms.
That's
One is to constitute a joint property. Now,
You are the plaintiff?
I am the plaintiff.
Okay, so
Now, therefore, what is still
the claim for adverse possession was not decided.
that has been taken into consideration that is not barred by res judicata.
That's right.
Now again, then your lordship may kindly come to what has been happened after holding this. Lordship, just see paragraph number 22 at page 14. The concluding part of paragraph 22. Paragraph 22 is a long paragraph.
Yes.
It has been concluded in page number 14. Yes. Just towards middle हम पढ़ रहे हैं। अंतर्गत धारा 144 मिला हुआ है हमको। अतः अनुमंडल दंडाधिकारी द्वारा निरस्त कर दिया गया 144 और उसके विरुद्ध में प्रस्तुत निगरानी वर्ष 2002 में खारिज हो गई। ऐसी स्थिति में पत्रावली के उपलब्ध दस्तावेजों साक्ष्यों के आधार पर यह स्पष्ट है कि विवादित संपत्ति को खरीदने से के वर्ष 1978 से विवाद प्रारंभ हो गया और 2001-2002 तक विभिन्न न्यायालयों को चलता रहा। 2003 में यह बात संचित हुआ, जिसके भी स्पष्ट है कि विवादित संपत्ति पर वादीगण के परिवार को शांतिपूर्वक कोई दखल तो प्राप्त हुआ नहीं तो प्राप्त हुआ, न ही वादीगण का परिवार विवादित संपत्ति पर 1978 से दखलकार है। इस प्रकार बात बिंदु। Now it is based upon a proceeding under section 144 CRPC. So once 144 CRPC was decided against the plaintiff, therefore the learned court, relying upon that order, and held that there was no peaceful possession of the plaintiff. This is the only finding, but it has not negated the what has been told, the two alternative plea which has been taken by the plaintiff. Now your Lordship may kindly come to appellate court judgment. Appellate court judgment, your Lordship may kindly see para 20, Act page number.
Just a moment.
Yes.
Now the appellate court.
No?
Now you want to refer to the appellate court.
Appellate. Para 22, page number 10. In our page 10, running page 22.
Yes.
From perusal of the record, it appears that the appellant's plaintiffs could not rebut these evidence brought by the respondent's defendants, as they could not clarify that how these documents filed by the possession of the respondent defendants, which are exclusively related to the appellant plaintiff and were not in possession of the appellant plaintiff, and on careful perusal of an analysis of the record as well as the evidences produced by both the parties, it is clear that the appellant plaintiff majorly failed to establish the right, title, interest and possession over the suit land. So in my view, the learned court below has rightly decided all the issues, passed the judgment in favor of the student without specifying the discussion which has been made with regard to adverse possession. Now only because the document has been marked exhibit. Now if the documents are in possession of the defendants, can it be said that the document reflecting the title of the plaintiff, but it was produced by the defendant, therefore it will be presumed that the plaintiff has no right title interest. This is one part. Secondly, your Lordship may kindly see para 24, I do not find any irregularity or illegality in the judgment. So my humble submission to your Lordship would be that the learned appellate court did not take into consideration what has been painfully taken by the learned trial court with regard to res judicata, which has got two parts. This aspect has not been considered by the learned appellate court, nor there is any whisper or discussion in this regard as has been done by the learned trial court. So, my lord, I have, although my lord, majorly, my lord, I have formulated
There is no basis.
substantial questions of
है
law.
नहीं आपका basis.
अभी जो है,
नहीं.
Your Lordship Justice C.
अब
See.
order में कुछ नहीं है आपके केस में.
The findings of the learned courts below on the point of res judicata is not sustainable, whether the impugned judgments are vitiated on account of misinterpretation of section 11. Now the case which has been made out by the parties, the learned appellate court.
You as a plaintiff wanted to have a declaration of title and also adverse possession.
Not title. It is a joint property that declaration. Number 2, adverse possession. Now adverse possession I have already read the findings recorded by the learned trial court. Had there been any discussion by the learned appellate court or any points for consideration formulated by the appellate court? The Lordship just see, that is the reason I was referring, Lord. First of all, initially I referred the issues which were framed by the Lord at trial court. The Lordship may kindly see, para 12 is the only point for this.
You are referring to which substantial question of law?
B and C with regard to the res judicata. Because the learned trial court held that this will not be barred by res judicata, which I have just now read. But that has not been taken into consideration by the appellate court. Nor there is any point for this determination as required under Order 41/31, para 6, page 6, page 6, para 12. After quoting the issues, now to determine the appeal, in my view, the pertinent question is whether the appeal brought by the appellant is tenable in the eyes of law, and judgment and decree of the trial court is liable to be set aside. This is vagueness. Order 41, Rule 31 very specific, very clearly provides that issues are to be framed because it is the last court of fact. Then only can be addressed by in the latter part of the judgment. But that has not been done. Even the res judicata issue has not been framed. Points for determination is so vague. Therefore, the appellate court had no occasion to discuss with all these things what has been discussed by the learned trial court.
For the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 30/7/2016 within bracket decree signed on 11/8/2016 passed by the learned Judicial Commissioner Roman 17 Ranchi entitled appeal number 115 of 2008 affirming the judgment and decree dated 14/8/2008 within bracket decree signed on 22/8/2008 passed by learned Municipal Civil Court Khuti entitled suit number 7 of 2003. The learned counsel for the appellant has submitted that both the learned trial court had dismissed the suit on contest, and the learned first appellate court has dismissed the first appeal, and therefore the plaintiffs are the appellants before this court. The learned counsel submits that a plea of res judicata was raised before the court, and the learned trial court held that so far as the claim of title in connection with sale deed dated 12/5/1978 within bracket exhibit 7 is concerned, the same was barred by res judicata as the issue was already decided between the same parties in title suit number 130 of 1980, wherein the in title suit number 130 of 1980. He submits that the learned trial court, however, held that the plea of adverse possession is not barred by res judicata. The learned counsel further submits that the learned trial court after considering the materials, including the order passed, including the fact that one proceeding under section 144 CRPC was instituted way back in the year 2001. And also considering that the टाइटल सूट का नंबर क्या था 130 और 78 और 80
80 यहाँ लिखा हुआ बात संख्या 130/78
हाँ
बदस बी में विवादित संपत्ति पर
उसमें हाँ उसमें 80 लिखा था दूसरा जगह पर and also the
बदस बी हम देखा जाए पेज नंबर 6 ट्रायल फॉर जजमेंट का
and also the fact that the parties were in litigating terms in title suit number 130 of 1980, which was fought up till which was fought till the appellate stage and was ultimately decided in the year 1995, held that the plea of the plaintiff was not entitled for the for the claim of adverse possession. The learned counsel submits that so far as the learned first appellate court is concerned, neither the plea of res judicata nor the plea of adverse possession has been decided by considering the materials on record, and has submitted that substantial question of law number B and C, proposed substantial question of law number B and C arise for consideration in this case. B quote करेंगे whether the finding of both the learned courts below on the point of res judicata is not sustainable in the eyes of law. C. Whether the impugned judgments are vitiated on account of misinterpretation of section 11 of the Code of Civil Procedure. After hearing the learned counsel for the appellant, this court finds that the suit was filed by the plaintiffs seeking a declaration that the suit was a joint Hindu family property and the defendant / respond number 18 was a joint Hindu family property of the plaintiffs and the defendant respond number 18 as the same was acquired from the ancestral joint family fund and they came in possession of the suit property after purchase through registered deed of sale dated 12/5/1978. Here, 18 was a pro forma dependent. From Lakshmikant Chatterjee, and since they are in continuous possession for more than 25 years, in open assertion to their title to the knowledge and exclusion of all concerned, including defendant number 1 to 17. On the other hand, the case of the defendants was that the father of the plaintiffs, within bracket defendant number 18, had earlier instituted a suit numbered as title suit number 130 of 1980, which was dismissed and decree was passed in the same suit and was confirmed by the High Court. The present suit was alleged to be barred by the principle of res judicata. Further, it was the case of the plaintiffs that the defendant number 18 in their written statement had admitted that the joint family fund and the resources of family of the defendant was utilized for acquisition of property at Bundu, including the suit property. the dependent number 11 to 17 had contended that he on his own and not representative of the Karta of the joint family had conducted the earlier litigation. आपके लिए को ठीक से लिखा ही नहीं है।
नहीं लिखा, फैक्ट भी नहीं लिखा है फिर
Just a
सेंटिस
minute.
हिंदी में है ट्रायल पड़ जाएगी।
कोई बात नहीं, हम ट्रांसलेट कर देंगे। It was the case of the defendant that the suit was barred by res judicata in view of the earlier title suit number 130 of 1980, which was filed by the present defendant number 18 and was dismissed on 19/9/88. Against which title appeal number 86 of 88 was dismissed by judgment dated 12/6/1994, and second appeal number 76 of 1994 was also dismissed on 24/3/1995. It was also asserted that the plaintiffs had claimed that the suit property is a joint family property, but the sisters of the family were not made party in the proceedings. The defendants also denied the claim of the plaintiff that they were in possession of the property since 1978, disputed property since 1978. The plaintiff have not stated that the house, the constructed house situated on the property was constructed by them, nor they have made any such claim. It was also asserted that there was a proceeding under section 2 in the year 2001 under section 144 CRPC, which was dismissed on 11/2/2002. And the application of the defendant number 18, the father of the plaintiffs, for demarcation of the property was also rejected by the circle officer on 11/9/2002. The learned court framed the following issues for consideration. Whether the suit is maintainable, same issues, man.
हाँ जी,
issues में पेज नंबर 6 में appellate court judgment.
उसके नीचे उनका डिटर्मिनेशन पॉइंट फॉर डिटर्मिनेशन.
That's right, we'll see that. The learned trial court held that the learned trial court by paragraph 18, the learned trial court considered all the materials on record and ultimately by paragraph 18 held that the earlier suit of the year 1980 was filed by the defendant number 18 of the present suit, and the plaintiffs are the sons of defendant number 18, and was of the view that the judgment passed in the earlier title suit hearing number 130 of 1980 was binding on the parties, and the present suit was barred by res judicata. The learned court further considered the plea of adverse possession in paragraph 19 of the judgment and held that and observed that the plaintiff claimed that they were in continuous possession of the suit property for last 25 years, and therefore they have acquired title by adverse possession. The plea was rejected by observing that the parties were in litigating terms in title suit number 130 of 1980, which and at that point of time there was no question of adverse possession, inasmuch as the property was purchased only in the year 1978, and therefore the point of adverse possession was not involved in the earlier title suit. And therefore observed that the plea of adverse possession was not barred by res judicata. Thereafter, the learned court considered the materials on record from paragraph 20 onwards with respect to the plea of adverse possession, and after considering both oral and documentary evidences based on record, held that the plaintiff has failed to make out a case for adverse possession, and the plaintiff had not acquired title by way of adverse possession. While deciding their proceed, the learned court recorded that the court inter alia recorded that the parties were in litigating terms in the title suit number 130 of 80, and the judgment passed in the title suit attained finality only in the year 1995, when the second appeal was ultimately decided by the High Court. And there was also a proceeding under section 144 CRPC in the year 2001. In that background, the court held that the plea of adverse possession, and in that circumstances, the court decided the point of adverse possession against the plaintiff. and clearly held that the plaintiff were not in peaceful possession of the property since 1978. The learned first appellate court has framed the point for determination in paragraph 12 and has observed that the pertinent question was whether the appeal brought by the plaintiffs was tenable in the eyes of law, and the judgment and decree dated 14/8/2008 passed by the learned court in title suit number 7 of 2003 was liable to be set aside. The learned first appellate court in paragraph 14 observed that the point of res judicata was one of the prominent issues to be decided in the case. The learned court thereafter observed in paragraph 17 that in order to operate as res judicata, the finding must be such that it disposes of a matter that is directly and substantially an issue in the former suit, and that the said suit must have been heard and finally decided by the court trying such suit, which is collaterally or incidentally an issue for the purpose of deciding a matter which is directly an issue in the case, cannot be made the basis for a plea of res judicata. The learned court then recorded in paragraph 20 that the plaintiff had admitted that their father, within bracket defendant number 18 in the present case, had instituted a title suit for the suit land in the court of subject Kuti by title suit number 130 of 1980 within 2 years of their purchase, but the suit was dismissed. And the title appeal number 86 of 1988 was also dismissed on 2/6/94, and further second appeal was also dismissed on 24/3/1995. The learned court then held that the learned trial court had rightly observed that the suit was barred by res judicata. The learned court thereafter, in paragraph 22, observed that the appellants could not rebut the evidences brought on record by the defendants, by the contesting defendants, and as they could not clarify as to how the documents filed from the possession of the defendants the learned court recorded that the learned trial court had rightly that the plaintiff had miserably failed to prove their right title, interest, and possession of over the suit property. This court finds that though the learned first appellate court has not in particular referred to the various documents which were placed on record while deciding the plea of adverse possession, but has observed that the plaintiffs has failed to establish right title, interest, and possession over the suit land, and this was recorded after perusal of the evidences produced. The learned trial court has considered all the evidences placed on record, including the documentary evidences. The fact remains that the title suit stood contested till the second appellate stage, which was ultimately decided in 1995, and a proceeding under section 144 CRPC was also instituted in connection with the suit property. Therefore, the court has rightly held that the basic ingredient of adverse possession was not satisfied. Accordingly, this court is of the view that no substantial question of law is involved in this case, which is accordingly dismissed.
Item 17, second appeal 182 of 2018.
This is plaintiff's appeal against the judgment of reversal. The plaintiff in this case are the sole granddaughter of the recorded tenant, and they are in possession of the property in continuous possession, and rent receipts have been issued continuously in favor of the plaintiff.
Sole granddaughter of the recorded tenant.
Recorded tenant. There were three recorded tenants of the suit property members: Kalidas, Chittar, and Chutu.
Just a moment. Who was the recorded tenant?
Three recorded tenants.
Yes. Kalidas,
Chittar, and Chutu.
Chittar.
Ah.
Chittar and Chutu. CHUTU. TUA. Chutua.
CHUT.
CHUT. She was the sole granddaughter of
Kalidas.
Kalidas.
Chittar and Chutu died is
The plaintiff.
present plaintiff. Presently, they have been subsequently substituted by the legal heirs.
Sole granddaughter.
So okay.
Okay.
Kalidas was the only surviving recorded tenant.
Died issueless.
Chittar and Chutu died issueless. Kalidas has a single son named Junko.
Junko. Son.
And the present plaintiffs are the daughter of this Junko.
Okay.
Well, they were in the continuous possession of the suit property,
Entire.
property.
What about the legal heirs of Chittar and Chutu?
They died issueless matters. Their property also demand.
They had no agnates?
No.
No agnates also?
No, it's only three brothers. So the
They were all brothers. Kalidas, Chittar and Chutu were brothers. Not necessarily. They were brothers. Okay, then what happened?
The defendant's claim of the suit property is based on the fact that the parties are not governed by Hindwas Santhal customary law. The plaintiff claims that they are governed by Hindwas Santhal customary law, but the defendant disputes it and they contest the suit, stating that Hindwas Santhal customary laws are not governed by the party. The parties are not governed by customary laws. And according to their own custom, daughters are not entitled for inheritance of the property. And on this basis, they are contesting this suit.
Who are the defendants?
Defendants are claiming the father of recorded tenant. Father of recorded tenants has ignates and they are claiming from their hierarchy.
Father of recorded tenant means father of Kalidas.
Kalidas.
Had agnates.
Hierarchies. Kalidas and Ram were two brothers. They were recorded in MacPherson settlement. Right. They are claiming their title from MacPherson settlement. Whereas in
Kalidas and Ram were two brothers.
Kalidas' father and Ram were two brothers.
Kalidas
Father's name was Singri.
Sindri.
Singri. S-I-N-G-R-A-L.
Sindri.
R-A-L.
He had a brother called
Ram.
Ram.
This is the case of
defendants are claiming through Ram.
Ram. And they were already separately recorded in MacPherson settlement.
Separately recorded.
In MacPherson settlement. In Gangster settlement, the land is recorded in the name of Kalidas, Chittar and Chuttu.
Okay.
Defendants are
Who are Chittar and Chuttu?
Chittar and Chuttu are recorded tenants of the suit property.
They are brothers. Kalidas, Chittar and Chuttu are the brothers.
No matters, they are not brothers.
लिखिए तो. The learned counsel for the appellant has submitted that the suit property stood recorded in gangster settlement in the year 1937 in the name of
Kalidas, Chittar and Chuttu.
Kalidas, Chittar and Chuttu, and in MacPherson settlement in the year it is after or before?
Before. Previously.
And in MacPherson settlement, which was prior to gangster settlement, the suit property was recorded in the name of Singer and Ram.
Ram. This is the version of the defendant. What they are contesting.
Singer and Ram separately. Open लिखिएगा ना, it is the case of the defendants.
Defendant.
He has submitted that Kalidas was son of Singer was son of Singer, and the plaintiff was the granddaughter of Kalidas through his son, namely Jhumku. Okay. He submits that the plaintiff claimed to be a Hinduized Santhal and claimed inheritance over the suit property. But the defendants denied the claim of the plaintiff, and according to them, they are governed by customary law of inheritance, wherein the daughters are excluded from the suit property, and therefore they claim that the property would devolve in the descendants of Ram. The defendants are the descendants of Ram. यही है कहानी. Finding बताइए क्या. You are the plaintiff or the defendant?
Plaintiff.
Okay. What is the custom? Have they proved the custom?
No. They have nowhere they have proved the custom. The appellate court has formulated 2 points of consideration matters.
First, the trial court. What is the point for
The trial court
issues?
The trial court has formulated issue number 5, that whether the parties are Hindus or not. I would like to refer the same.
What is the finding?
The court has found in favor of us that we are following certain customs of Hindu, therefore we are Hinduism.
Okay, it was decided in your favor. You are the plaintiff. Okay.
Page 48 minutes.
Page
Of
40.
the lower court.
Okay, this was decided in favor of.
Plaintiff.
Okay.
Perhaps I would like to read page.
No, it's okay. What happened before the learned appellate? There is a judgment of reversal, no?
Minutes.
Please tell us what happened before the learned appellate.
Appellate court didn't consider the evidence on record of the depositions that has been given by the defendant witness. They have specifically in their deposition have admitted the fact that we are governed by Hindus customary law. They have also admitted that
Hindus customary law.
Hinduized Santhal law.
Okay.
They follow some customs of Hindu.
Sindoor and all these things, Doli and which is something which is very peculiar to Hindus.
That has been specifically.
Where is the finding of the learned first appellate? What is the point for determination?
It is 24 months. Point for determination has been given by the appellate court.
Okay.
First is whether the parties are Hindus or Santals, and secondly whether the parties are whether the plaintiff are right title in interest of the slope.
Okay.
In deciding the first point of determination, the appellate court has not considered the evidence of the deposition of DW3, 4 and 5, who have specifically have averred that they follow some customs and some rituals of Hindu society.
Three, 4 and 5 has been considered. DW 3, 4, 5 at page number 13.
Now for that only I want to place reliance upon the trial court observation in this particular issue. As at page 48, the trial court has discussed the entire deposition in an elaborate manner.
Page number?
Page 48, issue number 5.
Where is the discussion of evidence of these witnesses?
Page number 18 of the judgment, internal running page 18. The witness Barku Maradi DW3 statement. May I be permitted to read? The witness Barku Maradi DW3 has also stated that parties are Santhal and therefore the Santhal rights. The witness has stated also in paragraph 6 of his examination in chief that they are Santhal and therefore the Santhal custom. He has stated also that the daughter and daughter-in-law may not get succession in their locality. The witness has stated in paragraph 11 of his course examination that the daughter uses vermilion over her forehead after marriage and they wear sakha in their heads. He also stated that they remove vermilion and break sakha after death of husband. He also stated in paragraph 12 of the cross-examination that the bohar is given after death of Santhal. He also stated in paragraph 13 of his cross-examination that the Santhal boys perform Saraswati Puja and Kali Puja.
The witness?
Witness DW4 as stated in paragraph 3 of his cross-examination that his elder brother got no brother-in-law and therefore the wife succeeds the property of her father. He has stated that the son of his brother lives at her maternal uncle's house and cultivates the land. The witness has further stated in paragraph 5 of his cross-examination that he knows Bablu Marandi of village Radhamat who got no son and his daughter Sundari cultivates the land of her father. The witness Iswar Rambam has stated in paragraph 13 of his cross-examination that some family members are called in the name of Sibu, Gopal, Devi, Iswar, Sivalal, Lakhan and Rai.
Para 17.
Upon going through the opposite fact, it is evident that the plaintiffs have taken the plea that they are originally Santhal and they follow same custom like a Hindu, and they follow some old relics of Santhal also. The plaintiff has specifically pleaded in paragraph 1 of the grant that they follow the old relics of Santhal like Dharjamai marriage, the exclusion of daughter from inheritance in presence of his son and a limited right to wealth. The defendant has simply denied the state pleadings of the plaintiff, and he has not mentioned any specific plea regarding the custom prevalent in the locality to meet out the pleadings of the plaintiffs as rebuttal. The defendants have pleaded specifically in paragraph
DW2 also stated that for last several years they are fighting to get their status as Adivasi. DW2.
In other words, even in the written statement, the defendants have specifically admitted this fact that according to their story, the share of Kalidas is now being inherited by 5 daughters, 5 subsequent daughters of Kalidas. So in their written statement itself, they are admitting this fact that female
5
successors.
subsequent daughters of Kalidas. Kalidas never had a daughter.
Their version is that Kalidas has a son Jumbu. Kalidas married twice, and from the second marriage, he got 5 daughters, and they are presently in possession of that property, according to the defendant's written statement. So, which itself admits the fact that the defendants are admitting that female succession is prevalent in their.
Where do I get this? Is it mentioned in the information?
Yes, ma'am. Where the court has dealt with the WS of the defendants.
Tribal.
Right.
Okay.
Now let's try court judgment at page internal page 6. Married man. Page 6. The defendants have taken plea also that the suit is bad for non-joinder and misjoinder of necessary party. The defendants pleaded that save and accept, which are not specifically admitted in the defendants, the defendants deny of the assertion of plaintiff put the plaintiffs to stick to their own. The defendants have taken plea that the assertion as made in paragraph of the plaintiff is not true and denied by the defendants. They have further pleaded that the assertion as made in paragraph 2 of the plaintiff is matter of record and submission. The defendants pleaded also that the assertion as made in paragraph 3 of the plaintiff is not complete and wholly correct, but the genealogical table is given in the written statement. The defendants have pleaded also that the assertion as made in paragraph 4 of the plaintiff is admitted. According to the defendant, Chittar and Kalidas all died in and about 1939. Died after the death. This may be noted. After the death of Kalidas in 1950, the predecessors, in interest of those defendants, performed the last rites, Mukhagni and Shraddha of Kalidas, which itself they are accepting that they were following Hindu. Even if this is assumed to be true, they are accepting the fact that they were following Hindu customary rituals. The defendants have further pleaded that the assertion as made in paragraph 5 of the plaintiff is wholly wrong.
Has the learned first appellate court dealt with the findings of the learned trial court?
No, ma'am. It does not specifically dealt with the
Has
findings.
not dealt or has not specifically dealt?
Not specifically.
Where is the finding regarding trial court?
At page,
Of the first appellate court?
at page 20.
No, I just want to know the first appellate court. Has it discussed the trial court judgment?
No, ma'am, it's not in detail. At page,
Even one line? Show me one line.
at
Where
page-
is one line?
at internal page 15 of judgment of appellate court, paragraph 15.
Yes.
Now the onus lies upon the respondent plaintiff to prove the fact that they are Hinduized somewhere. In the present case, I find that the respondent number 1 plaintiff has clearly admitted in paragraph 22 of her
But
process.
there is no discussion of trial court judgment.
Not specifically.
Nothing.
Only on the last paragraph it has
तो
mentioned.
बोलना ही पड़ेगा ना. Where is your substantial question of law?
Substantial question of law found at third question I am in the third, fourth, and fifth.
KSA number 182 of 2018. The learned counsel for the appellant is present. The उनको कुछ लिखा है क्या? आपको लिखा है क्या? He has submitted that the suit was decreed by holding that the family of the plaintiff was Hinduized sometime by considering the materials on record, both oral and documentary.
That's one more submission I would like to put. That's even if it is assumed that the parties are not bound by Santhal customary law, the onus is upon the defendants to prove the fact that in their customary law there is a ritual which prohibits female inheritance. It is the onus upon the defendants, and they have miserably failed in the entire suit to prove that.
Was it in dispute that under Santhals the daughters do not inherit?
According to their government, they are averring that since female are not allowed to inherit in their customary law, and therefore the trial court formulated this question that whether the parties.
The very fact that the plaintiff asserted that they are Hinduized Santhal and then claimed inheritance, they are conscious of the fact that if they are not Hinduized, they are not entitled for inheritance.
That's the observation of the appellate court. It says that since the parties are not Hinduized Santhal, therefore they are not governed by the Hindu Succession Act, and therefore the female are, according to the customs of the Santhal, female are not allowed to inherit the property. It is the observation of the first appellate. So if Hindu Succession Act is not applicable to me, and if I am not allowed to succeed inherit.
I will frame a substantial question on that. But I was just thinking that it should be properly framed. नहीं तो क्या आंसर आएगा? टेढ़ा मेढ़ा आंसर आ जाएगा. गलत क्वेश्चन होगा तो गलत आंसर आ जाता है. इसलिए क्वेश्चन को सही से the first appellate court has reversed the finding by holding that the parties are not Hinduized Santhal and they belong to Santhal community, and as such the provision of Hindu Succession Act 1956 is not applicable. The learned counsel for the appellant has submitted that while reversing the finding of the learned trial court, the learned first appellate court has not at all discussed the finding of the learned trial court and has accordingly not met with the reasons which has been assigned by the learned trial court to decree the suit. He has submitted that the evidence of the defense witnesses, the evidence of DWs have also not been properly appreciated, and there is have not been properly appreciated in as much as the evidence have not been properly recorded. Although the learned trial court had threadbare recorded the evidence. The learned counsel has also submitted that once the defendants were claiming, and that otherwise also once the defendants were claiming that the parties are governed by customary law and female and daughters are excluded, it was for them to prove the custom. He has also submitted that there was enough material on record to show that the close family members of the family were following the Hindu customs, and the daughters in their family were inheriting the properties. It admits that an appropriate substantial question of law be framed and the case be admitted for hearing. Considering the aforesaid submission and having gone through the impugned judgment passed by the learned First Appellate Court and also the judgment passed by the learned Trial Court, this appeal is admitted for finding hearing on the following substantial question of law. Whether the learned दिखाई दे रहा है? Whether the learned First Appellate Court, while reversing the judgment of the learned Trial Court, whether the judgment, impugned judgment passed by the learned First Appellate Court is vitiated on account of not following the mandate of Order 41, Rule 31 of CPC while reversing the judgment. Whether the learned judgment passed by the learned First Appellate Court is perverse, while on account of improper consideration of the evidence of the defense witnesses of DWs. Plaintiff का ठीक है? Plaintiff का ठीक है? Issue notice to the respondents for which requisites under speed post we filed within a period of 15 days from today. Call for the records from the concerned court. नाइन को भी कर देंगे. Deputy Commissioner holds this case on 6th of January 26 with the records before.
Item 18, second field table 3 of 2018.
Appellant number 2 and respondent number 2 are dying. For that regard, I advance agreement notice and statement.
When did they die?
That is not known.
For last couple of days we are giving this adjournment slip.
Madam, the reason being for today is that yes, on
When did they die? Date बताइए.
नहीं,
अभी आपके पास क्लाइंट से कोई मुलाकात नहीं.
नहीं, उसको फोन किए, उसको बोला पता करके आपको बता देते हैं. And the reason is कि इस बार नहीं आ पाया between 23rd to 30th उसके घर में मैरिज नहीं हुआ, मैंने हाथ का फोटो और 30th the marriage was celebrated, इसीलिए नहीं आ पाया.
अपीलेंट का भी डेट ऑफ डेथ नहीं पता हमको. अपने भाई बंधु का भी. Appellant number 2 has expired. Full brother. Appellant number 2 is सगा भाई है.
Because I asked him to give me the exact date. वो year से नहीं चलेगा, उससे नहीं.
ऐसे होता है कुछ भी बोलने से. अबेट हुआ है कि नहीं लिखेंगे ना.
स्वेरिंग करेगा या फिर उससे क्लियर हो.
बिना डेथ सर्टिफिकेट के नहीं मानेंगे.
Appellant number 2 का नाम. Appellant number 2 का नाम.
So far as you are concerned, you received information on 23/11.
Yes, sir. I inquired that parties are alive or not.
That's
Informed that appellant number 2 and number 2 are alive.
90 days कब एक्सपायर करना है? 23/11 से. February 22 के बाद पोस्ट कर देंगे. तब तक अगर आपका आईए अगर फाइल हो जाएगा तो ठीक है, नहीं होगा ठीक है ना. Because then the proceeding will abate ना. Then we will just decide the matter. Unnecessary date देके क्या होगा? हर डेट में आपका एडजर्नमेंट स्लिप आ. आपका पार्टी इंटरेस्टेड भी नहीं लग रहा है ऐसा खास.
दो बार हमने भी बोला उसको कि मैरिज.
You can't help it, no. If they are not interested, you can't help it. The learned counsel for the appellant has submitted that on 23/11/2025 he has received information from the appellant. Number 1, natural. 2 मर गया, 2 ही appellant. Appellant number 1, that appellant number 2 and respondent number 2 have expired. However, he is not aware about the date of death of these persons. He seeks adjournment. $90 days है ना substitution का. Let this matter be posted on 24th of February 26.
Item 19, second field 397 of 2018.
plaintiff appellant. I filed a suit. I'll just try to show that there was complete mistrial of the entire proceeding and which ultimately has seriously prejudiced the plaintiff appellant here. Now, Your Lordship, few facts are not clear from either the trial court record or the judgment. So my initial prayer would be that I'll pay a special messenger, lower court records may be brought through. But only to satisfy that the matter has merit, I'll just place what it matter. Now I file a suit again. There were three defendants which Your Lordship would see from the first cycle. Now initially I filed a suit only against defendant number 1 and 2, and then it was filed in the year 1999. In 2000, the these two defendants, they say that it is not your property, although the property is based on, my title is based on registered deed of settlement of 1940. But let us forego that for a moment. Now in 2000, the defendant, they say that it is not your property, it is the property of state. State files an intervention application in the year 2000, which is rejected by a reasoned order by the trial court, and thereafter the trial proceeds. After 5 years again, in 2005, again the state files an application under order 1/10, and this time it is allowed. By that time, my entire evidence has already closed, and now the trial judge, now he asks the state to file your written statement, and then the trial proceeds further without any opportunity to me to now amend my plaint or anything as against the state. Now this is one. This is only a technical aspect. My contention would be that this could not have been allowed. Once the original application under order 1/10 was dismissed, holding that the state did not have any right title interest, it was either for the state to have challenged the order further, or it ought to have subsequently, it could not have filed an impleadment application, and the trial judge did not have any jurisdiction to recall its own order. This is one, only on technical aspect. Now, on merit, Your Lordship, the state had in the year 1970s, when this was a property which was settled to me by way of a registered
If
deed
this
of
is the
settlement.
situation, then the matter has to be remanded.
This I do understand. Actually, Mr. I've gone through both the trial court and appellate court. Your Lordship, I can satisfy that the plaintiffs have seriously been prejudiced by the entire proceeding in the manner.
The property has been held to be the property of the state.
Yes. And interestingly, what has happened that in 1973, Your
When was
Lordship,
the first petition rejected?
it was on 6/9/2000.
6/9/2000. When was it allowed subsequently?
And Your Lordship, it is approximately 5 to 7 pages. Details, reasoned order, and then subsequently it is being allowed on Your Lordship may take one more date. My evidence is closed on 30/1/2004. Plaintiff's evidence is closed, and then it is being allowed on 1/4/2005.
And then no further evidence of the plaintiff.
No. Thereafter, it only directs the state to file written statement, and then
Second appeal number 397 of 2018. The learned counsel for the appellant has submitted that there has been serious irregularity in conducting the trial. He submits that the plaintiff had filed the suit only against one defendant. Two defendants, both sons of Ram Sevak Bhagat. However, the state filed an intervention application which was rejected on 6/9/2000, and ultimately the evidence of the plaintiff was closed on 31/1/2004. Thereafter, the state filed another petition seeking intervention, which was allowed on 1/4/2005, and the state was directed to file written statement, but there was no further evidence of the plaintiff. No opportunity to give further evidence of the plaintiff.
Evidence and even no opportunity to correspondingly amend my plaint as against this state.
Yes. And no opportunity was given to amend the plaint also. The learned counsel submits that the records be called and perused, and then a substantial question of law be framed. He submits that for this purpose, for this limited purpose, notice may be issued to the respondents. I will issue notice.
Yes,
It's
but
like
without
then and then.
admitting, I am not asking for admission.
So that they may also assist the court.
Yes, absolutely.
Considering the aforesaid submissions, let the records be called for from the concerned court. The notice be issued upon the respondents, Incovicat Deputy Commissioner,
Okay.
through speed post, for which requisites be filed within a period of 1 week from today.
My submission, one more line will be mentioned, because I am also relying on merit also, that the trial court has misconstrued on two vital exhibits, which are very,
Exhibit number.
exhibit numbers are 5, exhibit 5 and exhibit 13.
5 and 13.
5 and 13. And these are in a land ceiling case, this particular property, the state considers it to be mine, and it declares other land of mine to be surplus, and it takes that land, considering this land to be mine.
The learned counsel has submitted that otherwise also on merit, the impugned judgment suffers from misconstruction of exhibit 5 and 13, which were relating to land ceiling proceedings.
Land ceiling proceeding.
ठीक, notice cut.
Yes.
Post on 6th of January.
Yes.
Item 20, second appeal 109 of 1025.
Not today. What happened? You are the plaintiff or the defendant? Eviction appeal.
Yes, Lord.
You are the landlord or the tenant?
I'm tenant.
What was the ground for eviction? What was the ground for eviction?
Page.
default.
C also. D6.
The learned counsel for the applicant submits that the matter will be posted tomorrow. Post tomorrow.
Item 21, second appeal 177 of 2025.
Litigation suit for specific performance of contract. I am defendant, appellate. Suit is declared. Now, writing come to the trial court. It's a suit for specific performance. Section 16 finding has to be there regarding readiness and willingness. Kindly come to the issues framed by the trial court. Internal page 4 of the trial court judgment. Issue number 6A. Whether the plaintiff was ever ready and willing to perform his part of contract and is still ready and willing for the same. Now the finding is, kindly come to internal page 40. 6A is decided. Now argument of the defendants, argument of the plaintiffs, and then 5 lines. Finding is at page 50 by the trial court, and kindly see how readiness and willingness is pleaded and considered to be proved by the trial court. Section 16C of the Specific Relief Act deals with the provisions that no specific performance or contract can be enforced in favor of a person who fails to ever and prove that he has performed or has ready and willing to perform the essential terms of contract which are to be performed by him. And in its explanation, one says that where the contract involves payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit in court any money except when so directed by the court. Now, in the pleading, there is specific pleading of readiness and willingness, comma, the plaintiff has filed this suit paying ad valorem court fee on the entire consideration, major portion of which he has averred already paid, and only balance of rupees 25,000 is due for payment, for which notice explaining the intention in terms of payment was sent, which is proved by a copy of notice as Exhibit 2, acknowledgement Exhibit 5, postal envelope Exhibit 4A, having endorsement of refusal by serving him as Exhibit 4, and the resignation registration receipt of sending of 19/10/1995. In view of the facts, I find and hold that this issue is decided in favor.
What was the value of the
1,25,000 was due, 75 was paid, and which the plaintiff has ever said in coming after coming on the witness box that he was ready and willing. I have got the certified copy of his deposition. The plaintiff was examined as PW4. And then what the appellate court has done, I will come. What the appellate court has done, the appellate court's point of this determination is running page 18, internal page 7 of the appellate court's judgment. Only one point of determination, whether the trial court has committed any error in passing in order by overlooking the fact which the appellate claims to recast issue mentioned by him in para 1 of his submission. Now, in the entire judgment relationship, I can read from page 7 to 22. There is only one line with respect of this, and that is that page, and that is also page 24. Only the legal provision is quoted.
Claim to recast issue means what?
It's the prayer was meant that issue has to be recasted for the reason that it's a joint property. I am not the person alone who can transfer it. There are other legal heirs and there is sufficient evidence by the other defense witnesses that it's a ancestral property. There are other persons. How can I transfer entire? The trial could refuse that point, saying that if they can come in the witness box, why they have not filed any application for getting themselves repleted in this suit?
They are not necessary parties.
Entire property.
He sold the entire property.
More than that share, that is the evidence of DW5, that he bought the suit.
Or he sold his share.
Access to his share. That is the clear, I can read that. Two witnesses are there. One is the co-sharer DW2 and another is DW5. And the trial court says that they should have come and filed a petition for imprisonment. Having not filed that, then they cannot raise this point. DW5. यह कि विवादित जमीन मॉडल नवागढ़ी थाना नंबर 216 खाता नंबर सच एंड सच इंद्रवन दास के नाम पे सर्वे खतियान में दर्ज है। बक्सी आनंदरवन दास की मृत्यु के बाद मेरे दादाजी बक्सी विक्रम दास आजीवन का अधिकार रहे। यह कि मैं he is the separate person, DW5 is other than defendant। यह कि बक्सी इंद्रवन दास का मैं बड़ा पोता हूँ। बड़ा पोता होने के नाते पिताजी के जीवन काल से ही नवाडी की जमीन मेरे दखल कब्जे में है और जमीन का फसल अपने को वह तरुफ दायर करते हैं, वो सरकार को मालगुजारी और अन्य चीज अदा करते हैं। Then kindly come to para 6। मुंसिफ हजारीबाग न्यायालय में टाइटल सूट 12898 मैंने दाखिल किया है। इस प्लेंटिफ देयर इस वाद में प्रतिवादी संख्या 1 भोला प्रसाद है। भोला प्रसाद इस प्लेंटिफ। इस वाद में टाइटल सूट 9597 में मैं वादी हूँ। इन्होंने अन्य प्रतिवादियों के साथ एक जवाब दाखिल किया है। कांडिका 10 के अंत में वर्तमान वाद के वादी ने स्वीकार किया है कि ग्राम होलोंग और नवाडी की जमीन मुझे मिला है। So once this is the admission of the plaintiff itself in another title suit, which the witnesses come and the written statement of the plaintiff in another title suit is exhibited and said that there it is admitted that some other person is holding that property and it was by way of internal partition given to him. Despite that, the trial court says that no, I cannot go. Why this DW5 has not prayed for impeachment as a My submission is for giving any finding in terms of 16C, readiness and willingness are two separate issues. Readiness is that what he has done, 2 years he has taken no course of action, and 1 month prior to the completion of the deadline of agreement he sends a legal notice and thereafter files a suit for specific performance of contract without showing that what he has done for 2 years and 10 months, and mainly for the reason that it's a suit for specific performance of contract. Time and again under the Supreme Court says it's not enough to file within period of limitation. One has to explain that how diligently he pursued that. The plate never says that after entering into agreement for 2 years, 11 months, what he has done. Has he ever approached for that? If not so, and if there is no evidence, there is no readiness.
What is the finding of readiness and willingness?
That is the finding. That is no finding.
No finding.
No finding. I can read right from page 7 to 22. Only one line of readiness, willingness is quoted at page 24 in a bold line that the law requires this. That's it. And there is no finding, no discussion in which paragraph of plaint, which evidence supported by whom the appellate court comes to the conclusion. Rather, the appellate court has not even framed the point of determination, which is the backbone of the entire suit proceeding. It's a suit for specific performance. There has to be a valid contract and there has to be readiness and willingness. So this issue was
This was 25% of the amount,
yes.
of the consideration
Yes.
amount, which was yet to be paid.
Yes, and he never says in after coming into witness box from where he could have arranged that. There is no other witness in the
Only 25,000 कुछ नहीं होता. It is absolutely a relative
requirement of
concept.
law. He could have covered even a single line.
He
It cannot
stated
be.
so in the plaint that he is ready and willing to pay,
Yes,
but he did not depose before the court about his
yes, that
readiness
is
and
by
willingness.
further point of argument. And if he says so, in support of which evidence, which document, and how he has conducted himself for 2 years, 11 months. 3 years is the time for getting it executed. Admittedly, the agreement is of 16th December 1992, and the last date was 14/12/1995. He sends notice on the agreement date is 16/12/1992. 3 years time bound was mentioned in the agreement 14/12/1995. Deadline. He straight says legal notice sent on 25/10/1995. So what he has done to 1992, 16/12/1992 से 24/10/1995 तक वो कर क्या रहे?
कौन से आपका substantial question है?
But
ये 92 का agreement अभी execute होगा.
and that too with a joint property for which a title suit is going, and the witness comes and shows the written statement that the plaintiff of this case admitted that that is his property. Leadership can be. I have got the certified copy, the DW5, who is the actual owner, co-sharer with respect of that property. He comes, he says that he has filed title suit is pending, and this person is party there. And that is his written statement where he says so.
Whether he heard the learned counsel for the appellant,
It's
the learned
A.
counsel for the appellant submits that the agreement for sale is dated 16/10/1992.
16/12/1992.
16/12/1992, and the total consideration amount was rupees 1 lakh. And as per the findings recorded by the court, 25,000 was yet to be paid.
Admitted in plain.
He submits that 25,000 is 25% of the entire consideration amount. The learned counsel submits that readiness and willingness to pay the said amount has not been proved by the plaintiff. And in spite of that, the suit has been decreed by observing that only 25,000 rupees was yet to be paid. कब का ये सूट कितना दिन तक चलता रहता
1992
है?
का है.
सूट इज ऑफ 1992.
Suit is of.
क्या कर रहे थे इतना दिन?
Suit is of 97.
The suit
And,
has been
and
filed
he
in
has
the year
not even filed
1997.
suit promptly. That is,
Sorry.
he has not even filed suit promptly because notice was sent on 25/10/1995. Then the suit was filed after that 2 years of 1997.
The learned counsel submits that the notice for specific performance of the contract was sent on 25/10/1995, and the suit was filed in the year
1997.
1997. He has submitted that the readiness and willingness to perform the part of the contract has to be pleaded and proved that throughout the plaintiff was ready and willing to perform his part of the contract. Readiness and willingness are two different concepts, and each of the concept is required to be pleaded and proved. He submits that the judgment passed by the learned courts on the point of readiness and willingness is perverse, and the same does not satisfy the requirement of section 16 with bracket C of the specific rule. Considering the aforesaid submissions, this appeal is admitted for final hearing on the following substantial question of law.
A, B and D.
इतना सारा क्या बनाना है? एक क्वेश्चन बनाए.
It can be merged at page 6. Roman 13. Sorry.
Whether the learned courts have failed to consider the point of readiness and willingness in light of the requirement under section 16 with bracket C of the specific relief act. Whether the judgments passed by the learned courts are vitiated on account of non-consideration of the point of readiness and willingness in terms of section 16C of the specific relief act. Issue notice to the respondents for which requisites be filed.
Its leadership or other aspect was whether the property can be transferred by me or not, which is the evidence before the trial. Something which is not even mine.
Readiness and willingness is sufficient. Let notice be issued to the defendant, to the respondent for which requisites be filed under speed post within the period of 1 week preemptory. All for the records from the concerned court. Post on 6th of January 25. Next.
From Delhi for order will be back and forth. Second appeal filing number 000 of 2025.
There are two defects remaining. For which we filed an IN, this IN number 12027 of 2025. Wherein they stated the defects are the appellant number 1 in the decree under appeal has not been made party in the instant. He died during the pendency of the first appeal. That is stated that he died before the formation of the. And the second defect is that respondent number 5 in the instant memo is not party in the decree under appeal. Respondent number 5 is the son of that deceased party, and so we have made him as a party respondent under Rule 96 of the Jharkhand High Court rules. Therefore, we should clear those two defects within.
How can it be ignored? A person who was not made party during the pendency of the appeal.
His son is made party. So that person died during
He died during pendency of appeal, no?
of the appeal.
So the proceeding abated,
He was the petitioner. No, he was the appellant.
he was the appellant before the first appellate course.
He was the petitioner. He was the plaintiff as well as the appellant.
So the judgment is in favor of it.
Against him and his other.
So he was the appellant only, it was.
He was one of the
So, and so it was the duty of the two appellants to inform the court.
We've stated that they themselves were of old age and they are members of scheduled tribe and they could not inform therefore such an error has occurred from their
And the appeal has been dismissed.
Yes.
You have filed one IU.
Yes. Both the defects concerned is
IU number 12037 of 25. Counsel for the appellant submits that the interlocutory application has been filed for ignoring defect number 183 and 184 as pointed out by the stamp reporter. As per defect number 183. Defect number 183.
it must be at the bottom of the table.
No, it is just 67th of the defect, that will be it. As per the office note that appellant with respect to defect number 83, appellant number 1 in the decree under appeal has not been made party in the present memo. And with respect to defect number 184, it has been pointed out that respondent number 5 in the present appeal is not a party in the certified copy of the decree under appeal. The learned counsel has submitted that the original plaintiff number 1, who was the appellant before the learned first appellate court, had died during the pendency of the appeal, being title appeal number 34 of 2013. And he submits that so far as the respondent number 5 in the certified copy of the decree is concerned,
Respondent number 5 in the memo of appeal in the present.
the respondent number 5 in the memo of appeal is concerned, he was
Son of appellant number of the deceased, appellant number 1 of the first.
of the deceased appellant number 1 of the first appeal. And therefore, he has been made a party respondent in this case. He also died.
No.
During the pendency of appeal, Mangna ho raha hu.
Mangra was the
Okay.
plaintiff.
तो ये डिफेंडेंट नंबर 5 का क्या डिफेक्ट निकाला है रेस्पॉन्ड नंबर 5 का? He is already a party in the first.
He was not a party in the decree under appeal
Why?
because his father was there and his name was not substituted. His father's name was not substituted.
और यहाँ पे आप पार्टी बना दिया उसको.
Yes.
कितना रेस्पॉन्ड नंबर?
5. Pro forma respondent.
The learned counsel submits that the pro forma respondent number 5 has been made party, being the son of the deceased appellant number 1 of the first appeal. And therefore he submits that the defects be ignored. Can the appellant take advantage of their own wrong? You are at the wrong foot. When you lose, you say that somebody has died.
No.
Yes. When you lose, you say that somebody has died. Otherwise, you don't say anything.
But that is not a ground to challenge. It's a defect that has been pointed out.
let notice be issued on the interlocutory application to the respondents. Third, which requisites be filed within a period of 2 weeks pending. Post this case on 7th of February. अदर साइड को बिना सुने इस डिफेक्ट को इग्नोर नहीं करना.
Order set. Item 5, first of 21 of 2008.
Please.
There are two IAs that are pending.
Is it admitted? Is it admitted?
Yes.
It is not yet admitted.
Notices were issued to the respondents.
एडमिट हुआ है कि नहीं अंकित? मेरे बात का कोई जवाब नहीं दे रहे. एडमिट हुआ है कि नहीं हुआ? से केस एडमिट नहीं हुआ.
So notices were issued. Usually notices gets issued when the matter gets admitted.
No.
This is
Reputation
all-
में नोटिस हुआ. Section 5.
This is also, unfortunately, this could not come up earlier. This is also part of that batch matter which was remanded before the learned tribunal.
कौन से आईडी आपके पास?
The two IAs have shown instructions as per the office note. Is IA 6009 of 19.
6,000?
6409.
6,406. Substitution.
Yes, that has been turned instructions as the substitution has already been done by a judicial order. Another
The
IA
learned counsel for the appellant submits that IA number 6406 of 2019 has become infructuous as per office note, as the substitution has already been done by a judicial order, by the order dated 12/6/2019. Okay. Accordingly, IA number 6406 of 2019 is dismissed as not pressed.
RP 8307 was also an information petition disclosing the date of the details of
Just a moment. IA number 8037 of 2016, the learned counsel submits that the same was a petition under order 22/10A of CPC informing about the death of the
original respondent.
original respondent. He submits that the IA is closed. IA number 8037 of 2016 is closed. What else?
By order dated 26 September 2019, that is order number 10, which, although the notices were received by the substituted respondents, but one subclause 1 was received personally, 1-2 through his nephew, and 1-3 through his nephew.
Validly served.
But then the
Press tips.
bench had directed, and then the matter was dismissed for default.
Then what happened?
So it has been restored now. I will seek time to find requisites. But
इसका डिसमिसल ऑर्डर में सिंप्लिसिटी रेस्टोरेशन है या इस ऑर्डर को कंप्लाई करने का कोई टाइम है? The learned counsel submits that by the order dated 26th of September 2019, the appellant was directed to take press steps for service of notice upon respondent number 1 Roman 2 and 1 Roman 3, for which requisites were directed to be filed by registered cover as well as ordinary process. But on account of non-compliance of preemptory order, the appeal was dismissed. However, it has been restored by order in CMT number 105 of 2020. The learned counsel further submits that as per the fresh notification, the notice has to go to speed post. He prays for some time to comply the order dated 26th of September 2019, but instead of registered cover, he submits that appropriate order for speed post be passed. Considering the submissions, the order dated, the appellant is directed to comply the order dated 26th of September 2019 within 2 weeks to entry. However, the notice in the order dated 26th September 2019 should be taken out through speed post and not through registered cover as directed. Post on 6th of January.
Item 6, second appeal 318 of 2015.
Admitted second appeal. In an admission case, due to non-compliance of the preemptive order, the present second was discussed. They are to restore, and in restoration, after restoration, notice were issued. Thus, the summons were also issued. Bilateral file has appeared to me.
For all the respondents.
And there are not 2 IAs are there. 2s are substitution during the pendency of the present second appeal. Respondent number 1 and appellant number 1 has died. And 1 is for a stay application. 1 by 1. IA number 6525/2022.
Next taken. Date fixed
Day
है.
after tomorrow कर देगा.
Next week आएगा. अभी
ठीक.
कुछ बहुत corrections
ठीक है.